Thanks everyone for joining today, or if you're listening in, thanks for doing that. Interestingly enough, when we set out to actually schedule this webinar, we had actually done so to cover all of the legislation that's come out between, we'll call it March of last year up to this point. And that was before we had what's probably the biggest piece of legislation of them all so far, or one of, the American Rescue Plan Act come into play. And that's actually where we'll spend the most of our time today. But in this legislative roundup, we're going to cover, really at a high level, at least, all of the legislation that's impacted our world. And I think back, a year ago, I never would have thought that there had been so many provisions and pieces of legislation that would have come down to impact the FSA, HSA, COBRA world. It just always seems like, there are other pieces of the puzzle out there that needed to be addressed. But the way it's unfolded, there's been so many changes, some layered on top of one another, and it's created a lot of complexity, a lot of questions. So our goal is to walk through everything today, spend most time on the American Rescue Plan Act, that newest piece of legislation, and really give you hopefully an idea of what we know, what we don't know, and from an administrator's perspective, how we're going to treat these pieces of legislation and how we'll move forward. We will try to keep this to 30 minutes, but I can't promise that. So please don't hold me to that, because there is a lot of content to get to, especially when we get to the American Rescue Plan Act piece. If you have to drop off at 12:30 Eastern, no worries. This presentation is being recorded, like Julia mentioned, and can be accessed after the fact. But with the Q&A, we might spill over 30 minutes and into a little bit longer. That's one disclaimer. The other disclaimer I have, we don't always put this up with the webinars that we do, but we felt it appropriate here. I am unfortunately not a lawyer or attorney, nor am I a tax expert. So I don't want this information to be perceived as any type of legal guidance or tax guidance. It's really, an overview of the legislation from our perspective and what we know. But if you do have specific questions, reaching out to a benefits or ERISA attorney is definitely practical. And there are some pieces of this, especially when we get into the COBRA subsidy with the refunds that will apply, a tax expert might be helpful as well. So what is the presentation's purpose, and what are we bringing to the table, since we aren't bringing legal or tax guidance? What we are bringing to you is an administrator's perspective of all the legislation that's come out to date impacting FSAs, HSAs, and COBRA. So our job when this legislation comes out is to sort through everything and determine, okay, how are we going to help employers move forward? So when we sort through all of it, we determine, okay, what do we know? What's sort of still unclear? And usually when a piece of legislation gets put out, you end up seeing some additional clarifying guidance within the next few weeks that helps to button up some of the uncertainty and answer some of those unanswered questions. With the American Rescue Plan Act specifically, we have not yet seen that additional clarifying guidance. We do expect to receive it in the next week, 2 or 3 from the IRS and DOL, weighing in on some of the outstanding questions and hopefully firming that up. In the interim, we'll tell you again sort of what we know already and what our initial plan of action is for helping employers move forward. Again, most specifically with the COBRA subsidy, which is probably the biggest impact that we saw. So that's what we hope to bring to you today. Here's our agenda. We're going to first start with a brief recap of everything that's transpired over the last 12 months from a health and welfare administrator's perspective, give you a summary of what's come down and what employers have the option to adopt versus what's required. We'll move from there into a brief overview of the Consolidated Appropriations Act. This was the last really big piece of legislation that came out at the end of 2020 that allowed some pretty substantial changes to FSA plans. We'll move from there into a brief overview of what we're calling the benefit timeline extensions. This was actually legislation that came out last year, but there was some clarification and clarifying guidance that came out in 2021 that we think employers should be aware of. And then where we'll spend most of the time today is on the American Rescue Plan Act, specifically the 2 components that we deal with, which is the Dependent Care FSA increase and the COBRA subsidy. We'll talk about the employer requirements that are tied to those and how Sentinel is helping as an administrator. And then, as we discussed, we'll leave some time at the end for Q&A. I'll reiterate that this presentation is recorded. It'll be posted on our website under the webinars and events section. And If we can't get to all the questions today, and I actually don't expect that we will, unfortunately, we will make sure that we get back to everyone who has an outstanding question. That response will either come from myself, or if you work with Sentinel, it would come from potentially come from your respective account manager. So just wanted to put that out there now. All right, so let's jump in. So first, a recap of the health and welfare legislation that's come out to date. Thinking all the way back over a year ago now, I believe it was March 27th of 2020, the really first piece of substantial legislation that we saw was the CARES Act. And the CARES Act had a lot in it. But specific to this world, it had a very important function in that it brought back over-the-counter medicines and drugs as FSA and HSA eligible. And on top of that, added menstrual products as eligible, which were never eligible previously to that. We saw this as really the first piece that touched the FSA world because individuals were having a tough time spending their money. COVID had hit, the restrictions were in place. Folks were not going to get that elective surgery done. They weren't going, out and spending their dollars. So the idea here was there was more that someone could spend on. And technically this was an employer opt-in, but for most plans, the way that, FSAs work, it was a pretty broad distribution, and that's how we treated it within our client base. From there, the second piece of legislation that we saw was the joint notice. I refer to this in the agenda as the benefit timeline extensions. There was actually a piece of legislation or a notice that went with it. It was EBSA Disaster Relief Notice 2020-01 is really the first time we saw some clarification on this. And what this did was it extended out the timelines that are associated with COBRA elections, COBRA payments, and also claims filing deadlines, which is applicable to FSA and HRA plans. This was not an employer opt-in. This was something that was automatically extended out to individuals and plans that were impacted. And the way to look at it is, as of March 1st, 2020, there was a point in time where everything was sort of held or suspended. And to a non-definitive end date, these COBRA election payments and claim filing deadlines were really in that limbo and suspended. So we'll get into in a little bit, what did get changed, what was clarified in a second disaster relief notice, 2021-01, and what we know now about how we can move forward. Later on in 2020, in the May timeframe, we did see 2 additional IRS notices come out that impacted FSA plans. 2020-29 allowed mid-year changes for FSAs. It also offered a grace period extension for 2019. So what happened was, we heard employers and participants in FSA plans, again, they were stuck with balances and didn't know what to do. So this was the first piece of legislation that I think significantly helped to address that, where an employer could opt into allowing employees to make changes. And most likely the changes were going to be stopping your contributions for the year because you really wanted to stop the bleeding. You didn't want to contribute more to something that you don't know whether you're going to spend by the end of the year. So that was an employer opt-in. And second to that, IRS notice 2020-33 allowed for health and limited purpose FSAs to be increased in terms of the carryover amount from $500, which is the amount that it had been set at when it was first enacted in 2013, to $550. And beyond that, this amount was going to be indexed and would be a percentage of the contribution limit. So the contribution limit is $2,750. This will be 20% of that, meaning in future years, as the contribution limit increases, so does the carryover limit. And this was also an employer decision. Then we had this big period of time where nothing happened. And we went into a period of time where many clients of ours and employers have open enrollment going into the fall. And there was this big question out there. Okay, OTCs are now eligible. My employer maybe helped me stop my contributions by adopting the 2020-29 provisions, but I'm still stuck with money that I was not able to spend, especially, folks who have children in daycare and they set aside Dependent Care FSA dollars, and daycares were closed or they weren't sending their children to daycare. So there was this big question about what's going to happen. Is the government going to act? Well, finally they did. Unfortunately, it was on December 27th was when it finally got signed into law, but we finally did receive the Consolidated Appropriations Act. Subsequently to that, in 2021, there was IRS Notice 2021-15. But this was a really substantial piece of legislation that allowed, most significantly, for full carryovers for health and dependent care FSAs from 2020 to 2021, as well as 2021 to 2022, as well as grace period extensions for those where it applied. And this was something an employer could opt into. An employer still can opt into it. We'll spend a little bit more time on this in the coming slides. And then the American Rescue Plan Act, as I mentioned, dependent care increase to the cap, the maximum tax exclusion, and the COBRA subsidy. And we'll spend some time there today. On that one, we did put a yes, no in the employer decision because the dependent care is in the employer's hands. The COBRA subsidy is an automatic thing, or it's something that the employer cannot opt out of. So we'll get into that more in a little bit. Now, we put all this together. This was the list of substantial legislation that's come out to date. And of course, last Friday, we had another piece of legislation, or at least another IRS announcement come out that brought another change to our world. Thankfully, this was a positive one, but we did want to bring the news to everyone here today since we're talking about legislation and IRS notices that impact the FSA, HSA world. So last Friday, we had IRS announcement 2021-7. And this said that amounts that an individual pays for PPE, personal protective equipment, that is used to prevent the spread of COVID can be treated as amounts paid for medical care under Code Section 213D. Now, Code Section 13D is important because that's the code section that's used in FSA and HSA programs to determine which products and services are deemed eligible. So the IRS is saying that now things like masks, hand sanitizer, and sanitizing wipes, which were specifically called out in this announcement, are eligible under FSA and HSA plans. Beyond that, they have a retroactive effective date tied to this going back to January 1 of 2020. Now, what's interesting is there was some commentary in the announcement stating that plans may have to be amended to allow for this. And the way it's written was that these expenses are now, sort of qualify or count under Code Section 213D. Because many FSA plans, Section 125 cafeteria plans, use that 213D sort of language in their plan documents, it may be possible that plan documents don't have to be amended, and these amounts will automatically be included as qualifying expenses. For many of Sentinel's clients, that's how we're treating it. So if you're a client of Sentinel's and you have your FSA with us, your employees can begin submitting expenses for PPE really effective immediately. And again, with expenses that were incurred on or after January 1, 2020. And the good news is because of some of these benefit timeline extensions, we are still in a period of time where someone can submit for expenses that were incurred back that far. So again, you can see how all these pieces of legislation get layered on one another. This is good news because it gives just folks another way to spend their dollars. We'll be reaching out and doing more on this in the coming weeks, where we'll be putting information out to participants. There's been so much to try to sort through that we've really tried to focus on multiple things at once. And this is so new. It'll be something that we talk about more in the coming weeks. Just know that for Benny cards specifically, benefit cards, and for Sentinel, we call our FSA card our Benny card. It will take some time, much like with the over-the-counter products, for the Benny card to get caught up to the technology to caught up with now what's eligible. Anytime some new products get introduced as eligible, there's an agency, it's called CGIS, that oversees all the different SKUs, the UPC codes that can be deemed eligible. And what happens is retailers will go and actually download the new lists. Some do it on a monthly basis, some do it quarterly, some do it annually. But a retailer will have to go take that action in order for Benny cards to work. So we might see that certain retailers, the cards begin to work there, and then it'll sort of trickle down to probably smaller retailers over time. But again, good news, and we wanted to include it since it is just yet another thing that's impacted our world. All right, so let's move into some of these specific topics. We'll spend a little bit of time on the Consolidated Appropriations Act first. As we discussed, this was a significant piece of legislation that came out at the very end of 2020 and was important because folks were stuck with FSA dollars that they were not able to spend in 2020. And this piece of legislation gives them an out to be able to move that money into 2021 and potentially beyond. The very first piece of this from an FSA perspective is that it's allowing full carryover of health and dependent care FSA funds from 2020 to 2021, as well as from 2021 to 2022. Second to that, a plan can allow a grace period extension A grace period, for those that don't know, is an extra period of time, typically 2.5 months after the end of the plan year, where an individual can spend money, and if they incur a new expense, it'll actually reduce down the previous year's balance before touching any new balance. The reason why it's important that both of these are included is because some FSA plans have grace period, and this is now allowing that period of time to go from 2.5 months to 12 months. For plans that don't have a grace period, the full carryover might be a more advantageous method, allowing folks to carry over money for both health and dependent care from, again, 2020 to 2021 and 2021 to 2022. So this really solves that problem, but employers have to opt into it. It is not something that's automatic, and it's something a plan can adopt. There were 3 additional provisions that were part of this. I'll highlight them quickly. Post-termination spend down for health FSA, which means when an individual terminates employment or loses health FSA coverage, you can allow them to continue to spend their funds. A special rule for dependent care, whereas typically folks can only spend money on a dependent up through age 12, and when they hit age 13, they become ineligible. This special rule in some circumstances will allow individuals to spend dependent care dollars on their dependents up through age 13 until they reach age 14. And then lastly, we saw a mid-year changes similar to the one that we saw in 2020, a mid-year changes without the qualifying event, but this was for plan years that end in 2021. So 3 additional provisions. Now, if you've already adopted these provisions, great. And we've seen over 50% of our client base adopt at least one provision, with the vast majority adopting either number 1 or number 2, because again, that was the big problem that folks were trying to solve for. Employers are trying to give their employees an option to carry money over and not lose it. But if you have not adopted any of these provisions, you do still have time. It's important to note the way it was written in the CAA was that you actually have until the end of this year to formally adopt any of these provisions retroactive back to the end of 2020. It's rare in the health and welfare world that you can do something retroactively like this. Typically, plan amendments have to be done in advance. This is a case where, because of COVID and because of the way things were unfolding, you can actually do so retroactively. So if you have not taken action yet for 2020, you can still do so. And please reach out to your Sentinel FSA account manager if you want to move forward. All right, we're going to shift now into the second piece of this, which is the joint notice, final rule. It has a lot of names. EBSA Disaster Relief Notice 2020-01. You can call it a lot of things. We're going to refer to it as the benefit timeline extension. Let's just start with a summary of what this is. I referenced it in one of the earlier slides, but basically this is giving individuals more time to take action on certain benefit-related timelines. Specific to our conversation today, COBRA elections, COBRA payments, and claim filing deadlines are the 3 of note. What happened was, when this came out, and it came out in end of April of 2020, it said that March 1st, 2020 is being defined as the first day, or what they're calling the national emergency. From that point in time, these deadlines that we're referring to, COBRA elections, COBRA payments, claim filing, were suspended, or they used the word told. Basically, it was on hold until an undefined end date. The end date is the national emergency plus 60 days. And they're calling this period of time from March 1st, 2020 until the end of the national emergency plus 60 days, the outbreak period. So whenever the outbreak period ends, that's when whatever the timeline was, or whenever the deadline was, it kicks back in. So it's sort of on hold, it's sort of in limbo until it kicks back into gear. Now, this sort of last bullet here is important because the initial guidance said that there was a 1-year limit on these extensions. And there was a lot of confusion about, okay, what does this 1-year limit mean? Does it mean that a year from March 1st, 2020, everything kicks back into gear no matter when it happened? Or is it something different than that? So we went on, and unfortunately, we didn't get any clarifying guidance until the 11th hour. It came out, I think, the last business day of February 2021. We got EBSA Relief Notice, Disaster Relief Notice 2021-01, which gave us clarity on this 12-month, 1-year limit rule. What it said was each individual deadline can be suspended for no more than 12 months. What that means is instead of everything kicking back in on March 1st, 2021, 1 year from the start of the national emergency, instead, that's not the case. Each individual's deadline is suspended for 1 year until that deadline kicks back into gear. What that means is FSA runout periods, HRA runout periods, COBRA elections, and COBRA payments are all suspended from 1 year from the date that those deadlines, those specific deadlines would have started. To use a quick example, if you have an individual who became COBRA eligible on March 1st, 2020, they had a 12-month window where that election window was technically suspended, and their election window did not kick back into gear until March 1st, 2021. Using a similar example, if someone's COBRA election window started on September 1st, 2020, their election window is suspended, tolled for 12 months, and will kick back in on September 1st, 2021. With one important caveat. The caveat is that if this outbreak period, that's the national emergency plus 60 days, ends before the 1 year period is up, that's going to be the deadline that kicks into gear. So it's truly the earlier of the end of the outbreak period or this 12-month window. You can see how this is very confusing. And unfortunately, the clarifying guidance is really not what everyone hoped for. Everyone hoped for a clean March 1st, 2021, where everything gets released and everything kicks back into gear. That's not the case. So you sort of have to look at each date individually. Okay, when does my runout period for my FSA plan start? Is it after March 1st, 2020? If yes, okay, 12 months from that point is when it starts. Or if the outbreak period ends before then, that's when it's going to start. A good example to use is a common FSA plan year that we have is obviously calendar year. So for calendar year FSA plans, their runout period traditionally would start on January 1st. So if you think of 1/1/2020 to 12/31/2020, the runout period would have essentially started January 1st, 2021. With these extensions, the period of time is suspended, and it will either start on January 1, 2022, and that's when the 90 days or whatever it may be will start running. Or if the outbreak period ends before then, the first after the outbreak period is when that runout period will start again. Very confusing, I know, but what we've done to handle this legislation, since this is not something an employer can opt out of, if we administer an FSA or HRA, the runout periods are automatically extended. For the COBRA world, the beneficiaries have been informed of these deadlines. The previous information that folks got was about the timing of 12 months. And now it's, the previous information was about the end of the outbreak period. Now it speaks to the earlier of the end of the outbreak period of 12 months. So at least we have a definitiveness sort of to it right now. We're still waiting on the end of the outbreak period, which relies on the end of the national emergency. Let's all hope that that comes soon. And when it does, we'll have these deadlines kick back into gear. Otherwise, it's 12 months from the date they would have started. All right, let's shift now into the bigger topic for today, which is the American Rescue Plan Act. Now, the American Rescue Plan Act, we're referring to it as ARPA because everything in the benefits world needs a nickname, it needs an acronym associated with it. So ARPA is what we're going with. And what's interesting is, for those that have been in the benefits space for a while, if you've been in an HR benefits function, maybe you're a broker or a consultant, you might remember that in 2009, we had the American Reinvestment and Recovery Act. That was referred to as ARA. And now we have ARPA, and that's not confusing at all for folks, I'm sure. But in ARA, 10 plus years ago, we actually had a COBRA subsidy. And what it seems is that ARPA, which also has a COBRA subsidy, was very much modeled after ARA in many ways, with a few distinct differences. So ARPA, what we're talking about today, was signed into law on March 11th. It was a massive COVID relief bill, but the two things that we're going to talk about today are the Dependent Care FSA increase and the COBRA subsidy. So the Dependent Care increase, $10,500 for 2021, and 100% COBRA subsidy for assistance eligible individuals. We're going to start with the dependent care. And the reason we're starting with this is there's actually a little bit less to share on this front because there's more that's unknown on this front. I mentioned at the very beginning of this broadcast that anytime a big piece of legislation like this comes out, you get the legislation and everyone's really scrambling to understand it. We're working with, our benefit brokers, consultants, we're working with employers, we're working with ERISA attorneys, we're working with other industry experts to understand, okay, what's the ramification? What are they trying to say? There's a lot of interpretation going on. Usually within a few weeks, you do see some clarifying guidance when it's needed from the IRS or the DOL where it's applicable. And we really expect that the clarifying guidance we're going to receive from the IRS and DOL is going to address many of the outstanding questions that we have about both the dependent care increase and the COBRA subsidy. So wanted to put that disclaimer out there that we definitely don't have all the answers, and there are probably more questions than there are answers. Our guidance or our advice right now is, for the dependent care specifically, employers should really take a wait and see approach, wait till that additional guidance comes out, and then move forward. But let's at least tell you what we know about it and what we don't know. So ARPA provides a temporary increase to the dependent care annual tax exclusion limit up from the traditional $5,000 where it's sat at for 30 plus years to $10,500 for the 2021 calendar tax year. And I point out calendar/tax year because it is truly that. If you have an off calendar plan year, there are some nuances that come into play with respect to this rule because this is truly applicable only to the 2021 calendar or tax year. Now, why was this introduced in the first place? It seems like this provision was introduced to help give individuals the opportunity to spend more in their dependent care, be reimbursed more in their dependent care for the 2021 year. Now, why is that the case? So if you think back to when the tax exclusion was $5,000, individuals could contribute $5,000 in 1 year, and then typically if they got reimbursed $5,000 in 1 year, great. But there were scenarios where if someone was reimbursed more than $5,000 in 1 calendar year, they might face some tax consequence. So again, I'm not a tax expert, can't speak to the specifics, but essentially you would not see the full benefit of the $5,000 in reimbursement. Well, carry that forward to this, and now we have a situation where, because of the Consolidated Appropriations Act, folks have been carrying over balances from 2020 into 2021. They may be contributing more money in 2021 towards their Dependent Care FSA. So you very well might have folks who end up getting reimbursed more than $5,000 in calendar year 2021. It seems like this provision was introduced to not negatively impact individuals from a tax perspective who end up being reimbursed more than $5,000. And hopefully, they can be reimbursed up to $10,500 without any consequence. With that said, this provision seems to also allow individuals to now contribute up to $10,500 in the 2021 calendar year. Now, to be clear, this is not automatic. That piece of it is not automatic and would require an employer opt-in. But if an employer does decide to allow then, and again, we say wait until we get that additional guidance to know all of the ramifications of doing so. But if an employer does decide to allow that option, as an individual, I can contribute up to $10,500 for calendar year 2021, and most likely a plan amendment would be required to allow that. So what are the questions that we have? The questions, as you can see, are many and are as much as what we know. The first piece that's unclear is, okay, if an employer does decide to allow this increase, is that increase in itself enough to allow basically a mid-year change or a qualifying event, even if the employer didn't allow mid-year changes under the CAA or Consolidated Appropriations Act? So if an employer goes ahead and says, okay, Scott, you can increase your election up to $10,500, is that in itself enough for the plan to allow those changes without a qualifying event and without adoption under the CAA? It seems like the answer is yes. It seems like this is a significant enough improvement or addition of a benefit that would allow an individual to increase their election without a true qualifying event or without the employer having adopted the mid-year changes provision under CAA. But we do hope that the IRS will weigh in on it. Further, we want to understand if it's possible for an employer to allow employees to take advantage of this increased reimbursement limit without adopting the option for the increased contribution limit of $10,500. Again, that seems like this was the whole intention of this, and most likely it is plausible and allowable under the plan, but we want to see the specifics of that to make sure that individuals can take advantage of the full reimbursement limit, even if an employer is not allowing contributions up to $10,500 in this calendar year. To jump to question 3, the question that we have then as follows is, okay, if an employer allows for those $10,500 in contributions for 2021, and someone carried over money from 2020, and potentially they're reimbursed more than $10,500 in 2021, will that individual face tax consequences? It seems like they might, based on this new tax exclusion limit of $10,500. If someone goes over that in reimbursements, it may lead to an issue. But again, that's something we would like clarified. Number 4 is another question that we've seen a lot from employers. If you've ever been involved in non-discrimination testing, I feel bad for you because it's not a fun topic. I'm pretty involved with it at Sentinel, and the test that we see most commonly failed across the board of employers, all shapes and sizes, is what we call the 55% average benefits test for dependent care. And this test has historically been failed because it's unfortunately, in my opinion, inherently flawed in the way it was built, and looks at the dollars that are contributed across HCEs and non-HCEs, highly compensated employees. And because of that, typically employers will run into issues with it because typically you have higher earners who participate in dependent care. So the question is it possible that by adopting this increased contribution limit of $10,500, employers see increased failure or, just basically more issues with respect to non-discrim testing? We think that the answer is yes, most likely. You kind of think of who might be able to take advantage of something like this, put away up to $10,500 in a dependent care account. Most likely is someone who's more of a high earner, and therefore non-discrimination testing will become even more of an issue than it is today. Another reason to really think hard about whether this is right for your organization. But again, we think it's best to know all the facts and wait for that additional guidance before moving forward. And the last item for consideration is off-calendar plan years. This increase is going to create some complexity because, as I mentioned, this increase is temporary. It's only for the 2021 calendar year. So if your plan as an employer runs off calendar, you might run into an issue if you try to adopt this increased contribution limit where there'll be several months where folks can receive up to that amount or can contribute up to that new limit. But once you hit 2022, as far as it's written now, the limit reverts back to 5,000. So it might create a situation where contributions have to be front loaded, or you have to think about what's actually contributed in a calendar year, compare that to plan year. It raises a lot of questions and can lead to even more complexity. So even more to think about for off calendars, and maybe even more reason not to adopt an increased contribution limit. So more to come on dependent care once we get, hopefully, that additional guidance. And we'll certainly reach out to employers once we know all the facts and feel that we can guide you appropriately. All right, now let's shift to the COBRA subsidy, probably the most sort of significant piece of this discussion today. As part of ARPA, we saw that ARPA is allowing individuals who qualify to receive 100% subsidy for the cost of COBRA from the period of time of April 1 through September 30th of 2021. Now, these individuals who qualified, they're referring to them as assistance eligible individuals, or AEIs. So we're going to use that term throughout this discussion, AEIs, assistance eligible individuals. Now, whereas the dependent care is an employer opt-in, this COBRA subsidy is not. This is something that's automatic. If your plan is subject to COBRA and your individuals fit into the category of an AEI, there is no opting out of it as an employer. It's something that must be handled, save for very special circumstances. So what's the requirement here? The requirement is that an AEI must be mailed a special notice, which lets them know that they have a subsidy available to them from the period of time of April 1 through September 30th. On the next slide, I will get into who is an AEI. So if there are questions on that, just maybe table them for a moment. We'll define that a little bit more robustly in a moment, but we'll use the term for now. So if someone qualifies as an AEI, the requirement is that the employer sends out a special notice which notifies the individual of this subsidy. Now, I say employer because that's the way it was worded in this act. However, if you work with Sentinel as your COBRA administrator, this is going to be part of the service that we provide. And if you work with another COBRA administrator, most likely you'll want to talk to them, but it's probable that they'll help you with this mailing as well. But just wanted to point out the language in ARPA does refer to the employer being on the hook for this, so to speak. So let's say an individual is eligible, they're considered to be an AEI, and they get to benefit from this subsidy. So what does it mean? It means that that individual will literally pay $0 for their COBRA coverage from the period of time of April through September of this year, with the caveat being if their COBRA coverage ends before the end of September, that's when the subsidy is going to end as well. This in no way extends the amount of time that someone can be on COBRA. You still have the typical 18 months, or in some circumstances, it's more than that. This in no way extends that amount of time. It only provides for subsidized coverage throughout your period of COBRA. And if your COBRA coverage happens to go through September of this year, you'll receive COBRA coverage for free for up to 6 months. Now, when we're talking about COBRA coverage, let's define that a little bit more clearly. We're talking about medical insurance, dental, vision, and even EAP. EAP plans sometimes are part of the COBRA spectrum, not always. But that's what we're talking about when we mean subsidized coverage. So it does go above and beyond just medical. What is specifically carved out of it is health and limited purpose FSA. While those benefits, I would say, are rarely elected through COBRA, they are sometimes. So if an individual is considered an AEI and they want to continue coverage for a health or limited purpose FSA through COBRA, that individual would have to continue to pay premiums for the health limited purpose FSA, whereas the other benefits would be covered by the subsidy. Now, what's really interesting about this is typical COBRA, right? You lose coverage under an employer-sponsored plan. And the rule is that you have to elect coverage retroactive back to when you lost it. So as a COBRA eligible individual before this subsidy, if I'm offered COBRA, I can't just jump in a month later or 2 months after I lose coverage. That would be, creating an adverse selection opportunity. Instead, I have to elect coverage retroactive to when I lost it, and I have to pay those premiums. This subsidy is going to work differently. This subsidy can be treated almost like a second enrollment period in a sense, where an individual does not have to elect backdated to when they lost coverage. Instead, the individual can elect to start their COBRA on April 1st, 2021, in order to simply receive the subsidized coverage from April through whenever their coverage ends. Now, the interesting thing is we talked about the benefit timeline extensions, and this is again where you sort of see the legislation layering on each other, each one layering on the other. Because of the benefit timeline extensions, we have this extra period of time where an individual can elect COBRA backdated to when they actually lost coverage. So for many people, when they receive this offering of the subsidy, they'll actually have a decision point to say, I can either elect backdated to when I lost coverage, in which case I would have to pay the premiums up until April, or I can, which again is not typical of COBRA, elect only effective April 1st, 2021. I'll probably have a gap in coverage, but if I can live with that, I can elect as of April 1st and get the free COBRA until my coverage ends. I mentioned that I would talk more about who is an AEI, so let's get into that now. An AEI has 3 criteria associated with it. For starters, it has to be an individual who lost, employer-sponsored coverage, was offered COBRA, and the qualifying event has to be one of 2, either involuntary termination, and we stress involuntary, or a reduction in hours event, which doesn't have any qualifier of involuntary or voluntary associated with it. So it's important that we hone in on that involuntary, and I'll get into this more in a couple slides, but really part of this will be identification of who we think within an organization was terminated involuntarily, because on the surface, the way ARPA was written, involuntary terminations, that's someone who should receive this offering. Anyone who received a reduction in hours that caused COBRA, they would also receive this offering. And I'll get into the involuntary piece a little bit more in a moment. The second criteria of the 3 is that individuals' COBRA coverage, had they elected, typically 18 months, would have had their coverage cross into the subsidy period beginning on April 1st, 2021. So let's tease that out a bit. Obviously, if an individual is on COBRA today and their coverage is going to span into April of 2021, if they qualify, then their premium drops from whatever it is to 0 as of April 1st. But we're not just talking here about people who already enrolled in COBRA. We're also talking about individuals who were offered COBRA, they declined it, but had they elected, their COBRA coverage, again, typical 18 months, would have brought them into April of 2021. Even further, we are talking also about individuals who might have elected COBRA initially, dropped coverage, but had they stayed on, they also would have had coverage that brought them into April of 2021. So the easiest way to think about this is anyone who had an involuntary termination or reduction in hours going all the way back to November of 2019, if you bring that forward 18 months, that brings you through or into April of 2021. So we're talking again about anyone who experienced an involuntary term or reduction in hours COBRA event from November of 2019 to present, because that 18 months would have brought them into April of 2021. There are a few exceptions to that we'll think about and contemplate in a moment, but that's really who we're talking about here is our population. So again, not just folks who are on COBRA, but anyone whose coverage would have brought them into it had they elected. Now, the last piece of it, this is an interesting one. So the other criteria here is that an individual to be eligible for this subsidy cannot be eligible for other group health coverage or Medicare. Eligible for is the key. It's not that you're enrolled in, but if you are eligible for other group health coverage. So the way that we're interpreting that is, if you're eligible for maybe an exchange, a state exchange or federal exchange, that's not part of this. It's most likely coverage through a group health plan, through an employer-sponsored plan. So if I have the opportunity to get coverage through my spouse, that would make me ineligible for the subsidy because I am now eligible for other group health coverage, or if I'm eligible for Medicare. In a slide or two, we'll get into, as an employer, you don't have line of sight into this. As an administrator, we don't have line of sight into this. This third piece is actually going to be something the individual has to attest to. And we'll get into in a moment what that means. All right, a couple other things I want to reiterate here. First is that in no circumstance does this subsidy extend the amount of time someone can have on COBRA. Again, it's typically 18 months, and this does not elongate that in any way. The last piece that I'll point out is that this subsidy does apply to qualified beneficiaries who are on the plan at the time that someone had a qualifying event. But it's not a true open enrollment in the sense that if I elect this subsidized coverage, I am not allowed to add my spouse at that time. I'm not allowed to add dependents at that time. I'm not allowed to add plans at that time. I'm only allowed to elect into whatever I had at the time that I lost coverage. And, if I happen to be covering my spouse and my dependents at that time, if I happen to have medical, dental, vision, that's what I'm offered under COBRA, but I can't change that as a result of being offered this special subsidy. All right, let's talk about the requirements for employers and the timing of all this. So this bill was enacted on March 11th, and in it, it said that the DOL from that point has 30 days to issue what they call new model language to be used for this subsidy period, or to be used to make this subsidy offering. And we're referring to this offering as a special notice. So what it means is the DOL has until April 10th to release the language that we should be using in this special notice. As a COBRA administrator, we are absolutely going to wait until we see this language before moving forward. We know that we want to be as inclusive as possible. We want to make sure we're using the appropriate language. So we're going to wait to see this language come out before we help with sending out any special notice mailings. Now, the requirement, if you look at bullet 2, and again, the true nature of the requirement is on employers to satisfy it, but as a COBRA administrator, most likely, and as your COBRA administrator, if you work with Sentinel, will help you fulfill this. But the requirement is that this special notice be issued within 60 days of April 1st. So for anyone whose subsidy would be starting or eligible on April 1st, the mailing requirement is that May 31st, that special notice has to be in the mail. As a COBRA administrator, we're shooting for much earlier than that. We obviously have to wait until we see this language from the DOL, the special, the new model notice language. We also have to get some information from employers that we'll get into. But we're going to shoot for probably the late April, early May timeframe, even though the requirement is we have until the end of May. Now, from that point in time, the way it was worded is that from the time the individual receives this special notice, they will have 60 days to then elect coverage. And again, most likely they're going to elect as of April 1st because they now have the right to, and that's the point where it's free. Or in some cases, based on these benefit timeline extensions, they will have the opportunity to elect all the way back to when they lost coverage. But most likely, you'll probably see less people take advantage of that, and they'll elect as of April 1st. The last requirement is that an additional notice be sent, and we're also going to receive model language for this from the DOL, when the subsidy is nearing expiration. So within 15 and 45 days of the subsidy expiring, which right now that would put us in the middle of September at the latest, there has to be an additional notice that goes out to these individuals who are AEIs, informing them that their subsidy period is coming to an end. And if there's someone whose coverage goes beyond September, they have to be notified that they have the right to continue COBRA, but they would pay the full premium. All right, so let's give you a sort of a pictorial of the different steps here and the mechanics involved. So the very first step in this is the identification of involuntary termination. As a COBRA administrator, I can tell you that when we receive termination information, more times than not, we do not know if that termination was voluntary or involuntary. And I bet that's true for a lot of COBRA administrators. I bet that's true that a lot of employers aren't providing that information simply because most times it's not relevant. Unfortunately, it is relevant here. So as an initial step, we will have to work to identify who of the terminations is involuntary. And again, this goes all the way back to November of 2019. Before we end the presentation, I'll talk about how we're going to go about doing that for the groups that we work with. Once that's done, so once we have the model notice language, once we have the identification of who's our AEI population, the special notice has to go out. Again, as your COBRA administrator, this is something we'll work with you on, we'll help fulfill on your behalf. This is going to be the subsidy offering to those individuals. Step 3 is that the individual who receives it does have to take action. So again, because there are 3 components to this, and the third component is that the individual cannot be eligible for other group coverage, we cannot blanketly apply the $0 premium for this population until we receive back the form and the appropriate documentation from the AEI. And a big piece of that, the piece that they have to weigh in on, is that they're attesting that they are not eligible for other group health coverage or Medicare. So when they receive this special notice, there's going to be some language in it, basically explaining the situation and the fact that if they're eligible for other group coverage, they would not qualify for the subsidy, and they'll be attesting to the fact that they, are in fact truly an AEI. And there are, at least it was written in ARPA, some fines that can come along with it if someone tries to game the system or fraudulently attempts to say they're an AEI when they're actually not. All right, so let's say someone is truly an AEI. They send back that information to Sentinel, their COBRA administrator, or to you, the employer, if you administer your own COBRA. Once that's received, that's when you're allowed to apply the $0 premium until the end of September or the end of COBRA, if that were to come first. And if this is a situation where someone had not enrolled previously, obviously the other piece of it is you'll have to reinstate their coverage. And most likely it'll be reinstated as of April 1st. Although, as we've discussed, there is the potential it's backdated a little bit further. And that's going to be, the process for the rest of the time on COBRA and or through September. They pay $0, and if their COBRA goes beyond then, the premium will kick back in. Now, think of the processing for a COBRA administrator. As a COBRA administrator, we collect premiums from qualified beneficiaries. We'll continue to do that in the event where someone is a voluntary termination and they don't qualify for the subsidy, or if they're involuntary, but they have other coverage or are eligible for other coverage. We'll continue to collect premiums for those people. For those who are qualified and, are part of the subsidy program, they will not be sending us any premium, and it will be $0. So the big question employers have is, okay, the employee is not paying anything there, or the employee is not the right word. It's really the individual, the AEI is not paying anything for their premium. You as as the employer, most likely have an obligation to pay the carrier. Probably depends on whether you're fully insured or self-insured. But the employer is essentially on the hook for this until the time where you can get this money back from the government. The mechanism that it seems that employers will use to recoup this money is via your Medicare payroll tax filing. Again, I'll use my disclaimer. I'm not a tax expert, but from what I understand, for most employers, there is at least a quarterly filing done. And that quarterly filing will be your mechanism for recouping this money. Essentially, when you go to pay your quarterly or whatever it may be tax, you'll reduce that down by the amount that's been subsidized. And the good news is you can reduce it down not only by 100% of the premium, but the additional 2% that is typically charged by COBRA administrators, or if you happen to charge that on your own. So if you go to pay that quarterly filing and the typical tax would have been $1,000, let's say that just for easy math, you have individuals on a subsidy to the tune of $500, which includes the 2%. You're only going to remit $500 when you pay that tax. You're going to short it, whatever it may be, to sort of recoup that money for your organization. So what we'd recommend is if you have a payroll company you work with, talk to them directly about what they're doing about it. We know that some employers, the payroll company actually files this tax on their behalf. So it's definitely worth a discussion with your payroll company, payroll department. What Sentinel's role will be is we'll help you identify who is eligible and really beyond that, who has actually taken advantage of this subsidy. So we send out monthly reporting that goes with the monthly remittance. That reporting will now be broken down to show who is an AEI and who is not, and therefore what amounts you can recoup as an organization and what amounts you cannot for folks who are not part of this program. All right, we're getting close to the end, and then we'll open it up for some questions. I know we're well over time, so thanks for hanging in there. So let's talk about some outstanding questions that we have on the subsidy. I mentioned that there are some outstanding questions on dependent care. We have some outstanding questions on the COBRA subsidy as well that we're hoping are addressed by the DOL. The first question is, what is truly an involuntary termination? Now, this may seem like a dumb question to ask, or it may seem like a very obvious answer. If someone left on their own, okay, that's voluntary. If we terminated their employment, that's involuntary. Pretty clear cut, right? Maybe not so much, unfortunately. We think there may be some nuances in this. You think of an example where someone was working at an organization, and because of COVID, they didn't feel comfortable going to work, so they voluntarily terminated employment. Well, that you probably coded that as probably technically a voluntary termination, but is that involuntary because they felt they had no other choice? Tough to say. Or if I'm an individual who had to take care of a family member who got sick, well, I voluntarily left my company, but did I have a choice? So there's some confusion about this. We hope it's addressed. Unfortunately, if it's addressed, it may mean that it's just more broadly, this has to be offered to folks. As an employer, you don't always know why someone left your organization voluntarily. You might not have that information, so that might put employers in a difficult circumstance. We'll see how this is flushed out. For now, we say focus on the involuntary terms that you know, and we'll use that as our AEI population. If it gets expanded in any way, then we can address that at that time. What's interesting is that there's the inverse problem for the reduction in hours. There was no qualifier on it of involuntary or voluntary. So the way we interpret it is any reduction in hours event that caused COBRA would fit into this category of a potential AEI. So until we hear otherwise, we would say that's the way it's treated, but we may see that this is addressed in that additional guidance. The third item is, I mentioned there are some scenarios where COBRA can go beyond 18 months. Now, we're not talking about certain events like divorce or a dependent aging out. Those events aren't part of this. So again, the events are termination or involuntary termination specifically, or reduction in hours. Those other events that are typically 36 months, divorce, death, dependent age out, those don't qualify. But there are situations where certain states give extra time on COBRA. So the question is, how do those state continuation rules come into play? Or if it's determined that I am disabled, so if I have a Social Security disability determination, that actually allows me 29 months on COBRA. How does that come into play? Those are questions that we don't know the answer to and we need flushed out. The last piece is we do have a lot of employers who do sort of severance arrangements, subsidized coverage for a period of time. And the question is, how will that work when it comes to the refund? And the examples that we see typically are an organization might cover the cost of COBRA for several months, or they might allow an individual to continue to pay what they were paying when they were an active employee, the employee rate, while on COBRA for a number of months, and the employer will continue to pay the extra or additional premium that's not covered under the employee rate. So the question is, well, will an employer be able to recoup those funds that are part of a severance arrangement? We're not clear on this, but it seems like the answer is probably no. If there's a severance arrangement in place, there's been an agreement between the organization and an individual that the organization is going to cover the cost of COBRA for that number of months. So because that arrangement in place, is in place, the individual may be receiving the full subsidy through the government, but because there's already been this arrangement that says the employer will pay for X amount for X number of months, most likely whatever the employer has said that they'll cover cannot be recouped. So more to come on that, but just know that that's a question that's out there as well. The last piece of this, just to throw one more thing at you, this is not tied to the subsidy, but it is part of ARPA, and we want to make employers aware of this. There is an additional optional provision included in ARPA that is tied to COBRA, where an employer can allow AEIs to elect a different medical plan at the time that they're offered the subsidy. The caveat is the medical plan that's elected by the individual has to be less expensive than what they had when they lost coverage. So it can't be a more expensive plan. And this, unlike the subsidy, whereas remember the subsidy is applicable to medical premiums, dental, vision, this seems to only be applicable to medical plans, not to standalone dental and vision plans. So this is something that as an employer, you have the option to allow if you want to offer it to your COBRA individuals. Then at the same time they receive that language about the subsidy, they would also receive this option or language where they can change medical plans with, again, the caveat being a lower cost plan. In the conversations that we've had with employers, I don't see a ton of appetite for this. We don't know if it's going to be truly beneficial to individuals. And beyond that, it adds more complexity to something that's already pretty confusing. So we've seen a lot of employers say they're going to stay away from this, but just know that you as an organization, you do have the option to allow this, whereas the subsidies are not optional. This piece of it is. All right, so lastly, if you work with Sentinel for FSA or COBRA administration, you will be hearing from us. And we will be reaching out really to cover 3 requirements in terms of how we'll need to move forward. The first is that we'll need your assistance in identifying involuntary terminations going back to November of 2019. We're going to create a formal mechanism, probably an electronic form, that's going to be sent out within the next week or 2. And it's going to give you the opportunity to tell Sentinel how you're going to provide this information to us. That same questionnaire will also cover question 2. Just like we talked about the very last slide, you have the option to allow an individual to change medical plans. We're going to ask you that question. Is that something you want to offer? If so, we're going to include it in the special notice that AEIs receive. Separate from this, for those who we administer FSA plans for, in the coming weeks, once we are aware of all of the ramifications of this increased maximum, we will be sending out information and basically a plan of action for you to opt into with all of the facts laid out so you can do what's right for your organization. So that will come separate from the COBRA reach out, but just know that that's coming as well once we receive that clarifying guidance. All right, to wrap up, we do have some resources available. You can certainly use those links. We have COVID pages, and when we have our help center is always being added with, articles about not only the compliance side of things, but how to work best with Sentinel. And there's a help center for both the employer and there's a help center for employees. So please check those out if you haven't already, if you don't use those today. And with that, we are finally going to open it up to some questions. Just based on the timing here, I know we're coming up on even an hour, so well over the 30 minutes that we allocated. But I think we'll take a couple questions and just see what we can answer, maybe the common ones that have come up. And anything that we can't answer, I'll just reiterate that we will certainly reach back out to you. It'll come from either myself or from your account manager if you work with Sentinel today. So Julia, I'll kick it over to you. Are there any questions you think we should address, some common ones that have come in?
Yes, thank you, Scott. This was a lot of information, but a lot of really great information. And as you can imagine, we have quite a few questions coming in. So I will tick this one off first, and I assume this has to do with the COBRA subsidy. I assume that death qualifies as involuntary and that the employee's covered dependents would qualify as AEIs for this situation.
It seems like the answer is actually no, believe it or not. The event types seem to be termination and reduction in hours. It doesn't seem that death, divorce, and dependent age outs were addressed in this. We'll see if that gets clarified with the DOL guidance, but it seems like the answer is actually no, those individuals would not be AEIs.
Okay, and then we have a couple questions in this similar vein. Do these new rules that affect HSA plans also apply to HRAs?
New rules that apply to HSAs. Okay, that could be a couple different things. If that's related to PPE, which is the new expenses that are eligible, most HRA plans don't cover all 213 expenses. If a HRA plan does cover 213 expenses, it would also apply to an HRA plan where PPE would qualify. If I misinterpreted the question, sorry, we can certainly follow up. But if it's related to PPE, the answer is most likely no, unless the HRA covers all 213 expenses, which some do.
And then just a clarification question. When is the mid-year election change to FSA allowed? Is it June 1st, July 1st, or can you make changes at any time throughout the year?
Yeah, it's completely up to the employer. So with the mid-year changes provision, the IRS gave employers all the flexibility in the world. Now, with all the flexibility in the world could come more administrative burden. But as an organization, you get to define when changes are made, how many changes you'll allow, and you can put some limitations on it. We've seen a lot of groups say we're only going to allow 1 or 2 changes in the 2021 plan year. We've seen other organizations say we'll allow 1 change before, call it June 30th, and another change before December 31st. But if you adopt that provision, you as an employer get to define some of the nuances and when the sub provisions, we'll call them.
And we're right up on the hour, so I'll just read off one more question just to reiterate to Scott's point. If we didn't get to your question, we will be reaching out personally. If a client does not currently have Sentinel administering COBRA, would Sentinel be able to assist an employer with COBRA administration now and assist with this process and with prior AEIs?
Yeah, most likely, yes. We can talk to any group who doesn't work with us today and see if we can help. It's very possible. If the only tough part is the timing, right? We have a requirement to get out the special notices by May 31st. So that would have to be taken into consideration. We would have to, look at whether that's doable. If it's doable, then we could certainly help. If not, and we can't meet that deadline, it might be best to try to help you to handle it on your own. So we can certainly reach out to that group and see if we can help.
Excellent. Well, thank you again, Scott, for your expertise, and thank you all for attending. Keep an eye out for the recording later today.
Thanks, everyone. Have a great day.